So we are waiting Kohlbergers to start here. We are in 2 studios. Some of you have been in the other one with me. Okay, where am I? I need to get into the right studio. Okay, I'm going to mute you here. They're struggling to reach a verdict. They thought they had a verdict deafening. They told the judge, and then they knocked on the door again and said they did not have a verdict. So they are on lunch, and everyone is asked to remain in the building. And I am heading over to Kohlberger, but I will leave this studio open for you. For those of you heading to Kohlberger, see you in there. Okay. You're going to be listening, Christina? Okay, I agree. You got to get some work done. You go get that work done. Now, can you all hear me in here? No, Deanna, I did not get that. And actually, I am so glad you said that. Did you send that to me or did BHB? Because I have not received that. And I have someone actually, I've been trying to send her better ones, and it's just not what she's trying to focus on. Also providing me with characteristics of dog bites. So going to be very interesting once I get it together. But Deanna, did BHB send that to me or did you? Yes, we are in Kohlberger's room now. Hi again, Maria. But yes, I am definitely waiting for that, Deanna. I have been searching for that. So if you sent that or had BHB, can one of you tell me who sent it and I'll search it up again? You think they had a verdict, but the judge didn't like it, Shirley? We will see, won't we? I find it really interesting that they knocked on the door. BK is another check off your to-do list. Hey, Mark, we're getting through today, aren't we? Oh, thank you, Deanna. I appreciate it. Because that, I think, is going to do something really good for us. Yep, got to add those things. I even put down that I opened a second studio, wrote it down on my to-do list, and then checked it off. I'm now checking off that I opened a Diet Coke. I'll get another check when I finish drinking it. This will be Ada County, Boise, where Brian Kohlberger, who is charged with the slaying, unaliving of the 4 Idaho 4 students, Xana Kernodle, Kaylee Goncalves, I have a hard time with her last name, excuse me, Megan Mogan, and Ethan Chapin. So hit that like on your way in if you would. Thank you very much. Yeah, that's interesting that they had a verdict and then not one. And now we're going to find out on this one. What happened is Dateline released an episode. And if you haven't seen the Dateline episode on the Idaho 4, you'll want to watch that. True crime cases. Thank you. Thank you, girl. I'm writing it down right now. Sorry. So he is being charged with the unaliving of these 4 students creeping in the dark of the night. And if you have not seen the Dateline episode, do go watch it. The Dateline episode releases information. And if you know, there's been a gag order on this case, and even family members are not privy. Now, my StreamYard, by the way, is trying to drop me right now. I need to look for someone other than StreamYard. It's driving me crazy. My StreamYard Wi-Fi is trying to drop us, so I'll come back in if it does. So he is being charged, and this happened in November 13th of 2022. We are in 2025 now. They took the venue from Moscow, Idaho, and they moved it to Boise, to Ada County, because the defense wanted a fair trial. They felt they could not seat a jury in the small town of Moscow. Well, so they moved where it was going to be, which meant families of the victims had to take off work. They have to travel. They have to get hotels. And they had to, some had GoFundMe's going, donations, whatever, in order to be there. Now, because Dateline has released this information and there's this huge gag order, okay, Huge gag order. Even the families don't have a lot of the information. Hold on, let me tell. And Dateline has an episode. And if you, thank you, Deanna, that helps a lot. They had an episode, they released it, it had leaks in it, that the judge was very, very, very angry about Judge Hippler. Very angry. Hippler's from Koberger, right? Yeah, Hippler. Boy, we get all our judges' names mixed up and everything. So Hippler was very upset that there was a leak, all this information. So what does the defense do? The defense files a motion to delay in order to prepare now because these leaks are out. Well, here's how I look at it. I'm not an attorney. I'm not a criminal justice graduate. I'm nothing. But here's how I look at it. All of that information that was leaked, they should know anyway, right? Through discovery and the exhibits and all of that. They know how many times he circled the home, allegedly, if it was him in the car. They know how many times he circled the home before his car stopped. The crime was committed, and 20 minutes later, the car took off fast past the house. They know that. We didn't know it. We didn't know. We knew he was caught around the house, but we didn't know exactly how many times he circled. So there's lots of things in there that were released, but in my opinion, they would have known this anyway. They just didn't want the public to know it. But I don't know why that justifies a delay for the defense. Why they would have to prepare differently, because those points were going to come up anyway. Oh my gosh, deafening silence. Hold on one second. Deafening says, Jay, have you seen Reverend Tana's reading of this case? No, I have not. I was still traumatized back from her reading of Sebastian because she is often spot on. It's really something she describes actually connecting with his brain, and allegedly he had feelings of unaliving his own mother. Wow is right. Yes, stall tactic. Yes. And if you saw my video that I did on BK a few weeks ago when they had the last pretrial hearing, go watch the video if you missed it. Because when I was watching that pretrial hearing kind of by myself and replay, one thing that the judge was talking about is where they were going to keep the knife. They will be keeping it in a box, a box there. So it made us wonder. And you should have seen how uncomfortable BK was in his seat. And someone commented to me, Jay, were you looking at the prosecution? They were smiling once they released that about the knife. And I said, no, I didn't see that, but I was sure watching him. And he was real uncomfortable. They told him how to get the weapon into the building, the judge discussed with the U.S. Marshals, that it would be kept in the box. So is that a duplicate knife, a duplicate weapon? Is it one that was reordered on Amazon? Or did they find the weapon? I don't know. I don't know. Did you hear there is a police body cam speaking to DoorDash driver? No, I didn't. The DoorDash driver who dropped off Xana's food at 4 something? Maria, I don't know if they found it, but go watch my video. Because he specifically says where they're going to keep it and how to get it in the building. So it could be a replica to use for comparison. It could be a replica. Let me check our other studio just to make sure I'm okay. Okay. Okay, sorry about that. Pascal showed it. Thank you. You all are on it. No, but I will go watch that. I also wrote down something that, okay, Pascal Showed the body cam. I love Pascal. He's good. Perfect. Thank you. So I don't know what I was getting at, but I've heard the DoorDash driver says she's seen BK claims she parked right beside him. Huh. Interesting, Karma's mom. I will go watch that. But so here we have all these delays. Now we have them. They did discuss in full. Go watch my video because I pulled it right out of that long pretrial hearing. I had to pull that out. I pulled that out of there because when I found, oh, they're back again. Are they granting another delay? Hold on. No, I'm watching court TV and oh, here we go. Hold on. Let's watch this.
All right, this is CR 0124316665, State v. Koberger. On behalf of the state, we have Mr. Thompson and Mr. Horowitz. And on behalf of, when I should note the defendant is present with counsel, Ms. Taylor, Ms. Massoth, and Ms. Barlow. This is the time set for or at least the public portion of today's hearing is set for the motion to continue the trial filed by the defense. So we'll start with that.
Good afternoon, Your Honor. Your Honor, our motion to continue has been filed and is necessary to protect Brian Koberger's rights under the United States Constitution and the Constitution of the State of Idaho. Specifically, a continuance is necessary to protect his due process rights, his rights to a fair trial, his rights to effective assistance of counsel, rights to confrontation, Mr. Koberger's right to present a full defense, and if it should come to it, a fair sentencing hearing and to be free of cruel and unusual punishment. The record of this case spans 2.5 years, and it shows that this request does not come as a surprise. Looking through the history of this case shows that the defense has met challenges and difficulties along the way, but has been dedicated in meeting all of the deadlines. We have talked about the discovery issues in this courtroom before, and that in large part brings us to need a continuance. 68 terabytes of information is a huge amount of information. There have been 23 requests for additional discovery over the span of 2.5 years and 7 motions to compel. When I say that this doesn't come as a surprise, that this comes from the record, I would direct the court to look back to May of 2023 and June of 2023 and our second motion to compel. Included in that was what was known as Exhibit A from the defense, and that depicted how we were receiving discovery. So this is not a new issue. This is something that's been coming up for a long time. We were receiving discovery, but it was such that you would get a file that would say hundreds of photographs, hundreds of pages of reports, each having to be looked at individually to know what was there and then organized. This case has also faced unique issues, starting with the media coverage of this high-profile case, non-dissemination orders that were addressed in courts, and then the grand jury materials that we had to fight to get access to before we could properly challenge the grand jury indictment. We faced issues with discovery, particularly with the AUG materials. We spent a great deal of time trying to get access to those materials. Those were ultimately what we could get, was ultimately presented in a motion to suppress, and that's preserved should there be a conviction in this case. We faced venue issues in this case, culminating in the change of venue and bringing us to Ada County. At the first hearing in this courtroom, we discussed the discovery issues and not having read everything and being ready with a full investigation in this case. That was apparent through our motions to strike the death penalty, our motions to compel expert disclosures filed in September and December of 2024, and requests for more time to file our motions in limine that was granted in January of 2025. Throughout the course of the motions in limine and then a motion to strike death based on discovery issues in February and March of this year, the record is replete with notice that we are not prepared to go to trial in this case. The discovery is vast and we have not had a chance to review it all. That we met deadlines for experts shows our dedication to comply with court orders. It does not depict effective counsel ready to go to trial on this case. We would submit that it's the court's responsibility to assess this motion to continue with heightened due process that's required in death penalty cases. The death penalty case is different. That comes from Ford versus Wainwright at 477 U.S. 399 at 411. The court must be sensitive to safeguard every avenue of due process. The Idaho Supreme Court said the qualitative difference between death and other penalties calls for a greater degree of reliability when death is imposed, and that comes from State versus Creech, 105 Idaho 362 at 383. Looking at all of the constitutional rights Mr. Kohberger has, effective assistance of counsel really becomes the crux of how all of these other rights are covered for Mr. Kohberger. And effective assistance of counsel applies both to the merits phase and the penalty phase of a death penalty case. The courts are guided and counsel is guided by the American Bar Association guidelines on capital cases. Wiggins versus Smith, 539 U.S. 510 at 524 said the ABA guidelines are guides to determine what is reasonable. And that's talking about reasonable performance by defense counsel in a capital case. The Ninth Circuit in Andrews versus Davis at 944 F3D 1092 at 1109 relies on the ABA guidelines as the proper measure to test an attorney's investigation. In Idaho, our public defender statutes reference the ABA guidelines as applying to indigent defense. These apply to the full investigation of the merits phase and require us to raise all legal claims. They require us to perform a background on all witnesses that might be called, especially those being called by the state. That means that we have to review all discovery to be able to present a full defense for Mr. Kohberger. We cannot present what we are not aware of. I would note for the court that discovery has been ongoing. I received discovery just this week. It is discovery that I have not reviewed yet. Considering what's required at a penalty phase in a capital case, we're required to perform in a way that the jury can carry out their function of individualized sentencing. That means that Mr. Kohberger's background has to be known and investigated and ready to present to the jurors. Evidence of his character has to be known and ready to present to the jurors, and his circumstances have to be known and ready to present to the jurors. That's addressed in the Woodson case and in the Lockett case. The jury must have the opportunity to consider all evidence that may weigh against the death penalty, and that means anything from his life history. It is the duty of the defense to find and investigate all mitigating information. We do have several experts that would be ready for the mitigation portion of the case should the case reach that phase, and they rely on understanding family history and Mr. Kohberger's own history. They can only understand what they've been presented, and the investigation to fully evaluate needs to be thorough. That means that records have to be collected. That means that interviews, collateral interviews have to be done, and those have not all been completed. And it's not because of a lack of diligence in this case. Further, when things that are noted as red flags arise, those things must be investigated. Red flags aren't fanciful ideas of what else could we do in this case. There are real things that come up in the course of the investigation, and whether or not they're important to mitigation and presentation for a jury's consideration requires time to investigate and collect records. Documentation is very important. The court's aware that red flags have come up and they require further investigation. Those are issues that may mean a lot to the experts that would be ready to testify, but they can't be presented until there's a full investigation. They are things that might change the course of the evaluation or might require us to have an additional expert to help explain certain circumstances. And that's important for the individualized sentencing that's required by the Constitution. Your Honor, there have been numerous challenges with gathering records and interviewing collateral witnesses. I know the court is aware of some of those particular issues. I'm not going to highlight them now, but it's imperative that we be able to collect records and conduct interviews from other family members besides just Mr. Koberger and his parents. And it's also imperative that his history be complete with educational records, medical records, and those things are still being done to this day. The other reason that a continuance is appropriate in this case is based on the media coverage, the dateline issue that has been talked about in this courtroom before, and what's yet to come. The dateline episode wasn't just a one-time deal back in May. That continues to be talked about. Everything that happens in this case continues to be talked about, and this court has a duty, a responsibility to make sure that Mr. Koberger receives a fair trial. That comes from Shepard versus Maxwell, 384 U.S. 333. And a continuance may be the way that the court can best protect Mr. Koberger. That comes from Patton versus Yount, 467 U.S. 1025. In addition to what is going on with what happened with the Dateline episode, that's not all.
Now, can
There's
you
a book
hear
set to be
me?
released just a few weeks from
And if
now
you can
to
hear
be
me, do
followed
you
by
hear
a
BK's
docuseries on
courtroom?
Amazon Prime. There's a claim that there's inside sources that provide information in this case. At the very least, the moment we start
Yes, you hear
attempting to
BK's courtroom?
select a jury in this case, those things are going to be on everybody's TV, everybody's social media feed, and some of the very witnesses
You hear
that will be
me and
expected to
BK. Oh, crud. Okay, I'm going to have to
will be
mute
taking
BK
part
when the verdict
in
comes in then.
the docuseries at least, and maybe noted in the book. That is in and of itself an exceptional reason for us to have a continuance to let those things play out for a while. I would also note, Your Honor, that jury selection is going to be
Oh, you hear me, but not BK.
jury
Okay,
selection is going
perfect.
to be particularly challenged and will need a great deal of time.
Oh,
based
perfect. I
on
wanted to make
what's
sure,
happened
because
in the
then as
media
soon
and
as this one
continues to
comes
happen.
up,
Your
have
Honor,
the
our
sound on.
request is for a continuance in this matter to allow us to be effective and perform our constitutional duty for Mr. Koberger, to protect his constitutional rights, to make sure that we have fully investigated all mitigating circumstances so the jury, if it comes to it, can perform their individualized sentencing, judgment, and function, and to allow some space between what's recently happened in the media. Thank you.
May I, Your Honor? Of course. Thank you, Your Honor. I will.
So you hear
think,
BK on both
address
sides? Okay,
Ms.
hold on.
Taylor's argument sort of in the reverse order in which she raised the issues that she raised. I want to begin, though, by bringing us and the court back to what the standard is for this motion to continue as opposed to what might happen after a conviction with respect to ineffective assistance of counsel. Right now, the standard is whether denying a continuance would violate the defendant's rights by causing unfair prejudice.
And that is an objective standard that the court has, and the court has discretion on all motions to continue, including a motion to continue in a case such as this that involves the death penalty. What the defendant and counsel are asking the court to do is delay this trial because of their subjective, prospective beliefs about how an ineffective assistance of counsel evaluation would happen by an appeals court if there is a conviction. What this court should do is use its discretion and look at the objective record. The record supports denying the motion based on what the defense has been doing, continues to do, and will continue to do through the mitigation phase until the penalty phase, including presenting mitigation evidence that the jury will ultimately decide about if there is a conviction. The lens that the court should look at is well stated, through which the court should look at this motion is well stated in some Idaho case law and others. And if I can turn on the Elmo, do I need to hit this button, Your Honor?
And Clerk needs to switch it over.
Okay, thank you. So these are cases that we cited in our brief, and I wanted to start my discussion with them. I'll read the top case, which is an Idaho Supreme Court case, evaluating whether counsel was effective in a death penalty case. Counsel was not required to investigate defendant's entire life in order to objectively and reasonably present mitigation evidence. And then I like the way that the Seventh Circuit sort of rephrased the same principle by saying, I won't read the entire quote, Your Honor, but a scorch the earth strategy is not required. We're in a standard of reasonableness. And the record that is before the court, and I'll acknowledge we have not seen what specifics, if any, the defense has put forward in its ex parte filing.
It's kind of hard for you, I recognize.
It does, but we have not seen specifics. I did not hear any specifics from counsel just now about these witnesses need to be contacted, these records need to be obtained. And then the court, I think, mentioned at prior hearing we had when this was motion to continue was first raised, that the court would be looking at what admissible evidence the defense needs to obtain and what strategies would actually be used to fruitfully obtain that evidence. And we don't have anything specific that we can respond to about that. So I'm at a bit, Your Honor, but I think the record that we do have shows that the court can use its discretion to deny this motion to continue. What we did in our response brief, Your Honor, was to cite the fact that the defense has identified 55 defense witnesses for mitigation, and I think one was recently added, so we're up to 56, 132 exhibits to use at the mitigation phase. And with respect to the ABA standards, we're not saying the court should completely ignore them, but what we are saying is that the court should look at them for what they are, which is a retrospective tool for appellate courts to look at the performance of counsel after a conviction, not some checklist that needs to be religiously adhered to in order to actually get to trial. Even if the court were to rely on them heavily, though, the charts that we put together show that for each of the ABA guidelines categories that the defense has raised, we have seen evidence in the record that shows that they have witnesses to talk about those issues and they have discovery on those issues themselves. Now, defense has called that superficial, but we would ask the court to look at the tables and look at the witnesses that we've been able to identify for each category and also the discovery in the record. So, Your Honor, again, we think that given the legal standards here on a motion to continue, given the court's discretion, given that we are in a world where the court needs to satisfy itself that defense has done a reasonable job to prepare for trial, there's no basis for a motion to continue. Now, let me turn to some of the specific arguments. I can take this down, Your Honor. that Ms. Taylor raised. With respect to the media coverage, we acknowledge, as the court has, that will pose challenges for jury selection. The issue, though, is not whether there is a lot of publicity. We know there's going to be a lot of publicity regardless of when this trial happens. As Ms. Taylor said, people will continue to talk about this case. The issue is whether the court, using the procedures it has established, or maybe even modifying them as the court wants to, can seat a panel of impartial jurors. The Supreme Court of Idaho has found that despite widespread publicity, even on the day of jury selection, that is possible. That is possible in this case, despite the challenges. The other thing I would mention with respect to the publicity is that it puts us at the whim of the media. Every time there's a breaking story, every time there's a new book or a new documentary, are we going to continue the trial indefinitely? And that seems to be the danger in what the defense is asking for. We call it a perpetual continuance, and we haven't seen a proposal about when this trial could take place. If there's a continuance, what seems to be the strategy here is just to delay. And that leads me to, I think, the other point that Ms. Taylor raised, which was to say that this shouldn't be a surprise. It is a surprise to us that a motion to continue was made so late in the game, after, by the way, the trial date was used to oppose an extension that we filed for with respect to our mental health expert. At that point, the defense said we can't possibly go down this road or give the government the state what it wants because of the trial date. Once that issue is resolved, then we get a motion to continue. So I think what we have seen from the defense is that they tried to use the mass amount of discovery to remove the death penalty from the table. When that failed, now we have a motion to continue. So I do think timing is relevant here. Again, and it's not just that the defense waited so long, it's that we now have a very substantial record on which the court can deny this motion based on everything that's been put in front of the state and the court. In terms of the mitigation investigation, Your Honor, we believed but did not have confirmation that the defense had a mitigation specialist until the reply brief on this motion alluded to an affidavit that mitigation specialist submitted. So I don't know what that says. I don't know what the mitigation specialist has said, but the fact that there is a mitigation specialist, apart from the 3 attorneys and 2 investigators that are part of the defense team, that person has one role, as I understand it, which is to prepare for the penalty phase if we get there. And that person, that specialist, has still time to continue doing whatever work they told the court they need to do. Your Honor, again, I would try to get back to the record and ask the court to look at the objective record when evaluating this motion. 55 mitigation witnesses, over 130 exhibits, a very robust team on the defense side, which includes their retained experts. Ms. Taylor, and in the briefing, really honed in on this idea of a social life history for the defendant. I don't know if the court has read the expert reports of the defendant's forensic psychiatrist and then the licensed psychologist. I won't discuss the details in open court, but our position is that both of those specialists, well-trained, very experienced specialists, conducted significant, fulsome life history investigations. They weren't just looking at bare records. They were talking to people from the defendant's past, from his present, his family, and developed parallel life histories. And in their reports, as I read them, no red flags that needed further investigation were noted. Nothing about those reports appeared to be incomplete. And the experts didn't say, we are unable to reach the conclusions we need to reach for lack of investigation. So I think that is sort of proof in the pudding. We have a life history for the defendant. The defense has amassed significant materials. And I thought we were going to be solely talking about the mitigation case that still needs to be developed. That is not a basis for a continuance. And to the extent there are ongoing discovery from the state that Ms. Taylor alluded to, I can represent that most of what was just turned over was our investigators speaking with witnesses that the defense has disclosed. So that's the nature of that discovery, is us responding to discovery from the defense. And that will continue, of course, to occur as we lead up to trial and witnesses make statements that we need to disclose to the defense. So with that, Your Honor, I would again rest on the case law holding that a scorched the earth investigation is not what's required. And on the record before the court should exercise its discretion to deny the motion. If the court has any questions, I'm happy to answer those. Otherwise, we would submit on the record before the court.
Thank you.
Thank you.
Any reply?
Yes, thank you. I would start with noting that if the new discovery is the state's contact of witnesses we've listed, the state knows that there are mitigation witnesses that we've listed because we had to disclose them, but they are people that have refused to speak with us. That presents a challenge in the case. A lot of the witnesses that refuse to speak with us have to do with records, medical records, of Brian Kohberger, past treatment records of Brian Kohberger. Those are important things that
Yes, everyone was over in the
what they have
verdict.
to say,
and now they're
can't
coming
be
over here.
known to our experts until we have the opportunity to fully understand those things. And we continue to work on access to witnesses and access to additional information. Your Honor, I want to touch on just a couple of points. One, when the court considers a continuance and considers whether Brian Kohberger's rights are violated, his right to a fair trial, his right to confront witnesses and evidence against him, his right to present a full defense, and his right to effective assistance of counsel are implicated and laid out in our motion to continue. The ABA guidelines require us to do a full investigation. It's not going scorched earth to understand Brian Kohberger's full life history. These are things that are required. And we've done everything that we can. We have had a mitigation expert on the case. This is 2.5 years into a case, and the average for capital cases is 3.5 years
In federal court,
in federal court.
which moves at a snail's pace in its best day in regular cases.
I'm not a practitioner in federal court, so I don't have any basis to talk to the court about that. But what I can tell you is that a capital case where we have a client and we need to investigate both the merits phase and a penalty phase at the same time takes time. In any case, it takes time to do that. In this case, with the high profile nature and having people decline to talk to us presents a whole set of challenges that we have to find a way to work through. As the court knows, a lot of mitigation information is very sensitive information. It takes some time to be able to get people to talk about things. Realities exist too. Not all of the family members are in the same place. So there's travel that's required. All of those things take time to do in a case like this, to put all of that together. There was no delay in having a mitigation expert on board. There was no delay in getting investigators to work on the case. And as soon as issues became apparent, Mr. Kohberger's team did not delay in getting experts to help us understand specific areas of the case. Looking over the entire record, the court can see that the defense team has been diligent about discovery, about motion practice, about litigating issues in the case. There just still is a lot left to do. There is still a lot left that is not known. And Mr. Koberger has a right to go to trial with prepared counsel that have conducted a full investigation in both phases of the case. When you have a certain amount of information and there's this other stuff that's out there, that's a red flag, that's real, that you need to investigate, your experts can only do what's here, what's been investigated, what's been produced for them to assess. This whole other area, that land between the red flags and the investigation, that's an unknown area. That's where there's ineffective assistance of counsel. That's where there's not a fair trial. That's where there's not an individualized sentencing proceeding. And it's that area that requires a continuance in this case.
All right, I'll take the matter under advisement and get an opinion out in short order. In the meantime, I fully encourage everyone to continue as if the trial is going to take place when it is scheduled for. Again, I reserve the right to write the decision that I come to, but as of now, I would tell you that it's likely you're going to trial on the date indicated. All right. Is there any other matters that we need to take up in the public session before we break to go to the private session?
Nothing further in the public session, Your Honor.
No, Your Honor, I don't believe so.
All right. We'll take a 10-minute break while the bailiffs clear the courtroom and we set up for the private session. All rise, please.
has been filed and is necessary.
Is
Set of
fair.
Hold on, you all. Okay, those of you in here, they are not showing the rest of the hearing. So it is closed, the rest of it. So come on back over to Karen Reed. We're watching it, but the rest of this hearing is closed. It says the portion will be closed. Look back. Oh, sorry, I was talking so loud. Right there. So the portion of the hearing is closed at that point. So we will have to wait to hear the judge's decision on Brian Koberger. So I will go ahead and end this stream and we will head back over to Karen Reed. So they had just a few minutes that they talked. They took a break, and when they came back, that was not going, the rest of it was not going to be streamed. So I will keep checking on that to see if they're doing anything different coming back on, but let's close this out and head on back over to Karen Reed, who had a not guilty of second-degree murder. And this is BK, this is the pretrial to see if we are going to have the trial that is scheduled to begin August 11th with jury seating end of July. But we now have to wait for the judge's decision. So we're going to end here and head on back over to the verdict. Not guilty for Karen Reed.